All right. This hearing kicks off with what looks like a good deal on paper. But don't be fooled. In court, even a favorable plea comes with serious strings attached. Let's break it down.
Mr. Wynn, in cause number 25, DCCR 0750, you're charged with the second-degree felony offense of burglary of a habitation from April 29th of 2025. And how do you plead to that charge? I'm sorry?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you read.
Quick legal insight. Deferred probation means no conviction on your record if you follow every single rule. Slip up once, and that deal can turn into a full conviction real fast. High reward, but high risk.
Reached just for an 8-year deferred probation, there would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Do you understand? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Wynn is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea.
Notice what the judge just did. This is called a pre-sentence investigation, or PSI. It's basically the court saying, before I decide your future, I want the full picture. That report can make or break your outcome.
Sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Nichols, what's the state's position with regard to bond reduction?
There's quite a few misdemeanors, Your Honor, for burglary of vehicle and trespass, among a couple other things. We don't see any other felony cases. This burglary is against property owned by his mother. I don't believe it was her residence. I believe it was the place she owned. He went in there and essentially stole TV. So I do have some concerns, but his criminal history is not particularly extensive, Your Honor.
Just sounds like it's some of the same things, though, that I have some.
Correct. It's mostly burglary, several burglary vehicle charges, several trespass charges.
All right, I'm not going to adjust the bond at this time, just in case I want to do something up front based on that misdemeanor history. All right, we'll get the pre-sentence report, and then you'll get sentenced at the next court date. You can go back with the bailiff.
Thank you, Your Honor.
Thank you.
Judge, just so the court knows, because he was just asking, it looks, there's, almost all of those misdemeanors are from about 15 years ago, except for a trespass last year.
Okay, come
So I
back.
just wanted to make the court aware of that.
All right, so here's.
And just like that, plot twist, the bond gets reduced. This is the court giving him a chance to stay out, but with strict conditions. One mistake from here, that door slams shut.
Here's what I'm going to do, Mr. Wynn. I am going to reduce your bond in your case based on your plea agreement to $1,000. If you make that bond, a condition of it at this time is that you have no contact with your mom. Okay, you cannot go near her, any of her properties. Do you have a place to live?
I was gonna live.
With your brother? Okay, so now there may be a time when you can have contact, but at this point, because she's the victim in this offense, you are to have no contact, no communication. Obviously, that means in person, but it also means sending messages or text or anything like that. Do you understand? And what'll happen if you make that bond is the very first thing you need to do is go straight to the probation department so that they can do that pre-sentence report. If you don't do that, then you run the risk of me not accepting the plea agreement. Things could be worse. Do you understand? Okay, you can go back with the bailiff. You're Vonzil Hall, correct?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Hall.
Now watch this shift in tone. We're going from a probation case straight into a first-degree murder charge. Completely different stakes, completely different consequences.
cause number 24, DCCR 1747, you're charged with a first-degree felony offense of murder, and that is from August 10th of 2024. How do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Matuska? The papers on the computer that you just signed, did y'all go over those? Did he explain them to you? And do you understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like y'all have decided not on the cap, but on the...
That's correct, Your
Okay.
Honor. And despite what he said earlier, we've changed our mind to
Okay.
the original 35.
All right. Do you understand also, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Hall is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of murder. Sentence you in accordance with your agreement to a term of 35 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Matuska. You also should thank Mr. Matuska because he worked out an excellent deal for you on this type of case, and I can assure you if you had gone with the cap, things